My name is Nkechi Taifa. I serve as Senior Policy Analyst for the Open Society Foundations and the Open Society Policy Center, and I also convene the Justice Roundtable, which is a national convening of advocacy organizations working to promote federal criminal justice policy. I'm thrilled to have the opportunity to moderate this distinguished panel at this dynamic event hosted by one of the nation's leading legal organizations, the American Constitution Society for Law and Justice. Ironically, this forum falls on the very day, June 17th, of the 40th anniversary of the war on drugs, and we are suffering the consequences of that flawed war, which has resulted in decades of misguided policy decisions. When discussing criminal convictions, the conversation often focuses on the immediate sanctions which accompany the conviction: imprisonment, fines, probation. We must understand, however, that most convictions have collateral consequences that affect defendants long after they have completed their sentences. They can be denied the right to vote, automatically excluded from juries, legally discriminated against in employment, housing, education, public benefits. Over 700,000 former prisoners per year are reentering society, many of whom are victims of the long mandatory sentences meted out during the 80s and 90s, who served their time and have paid their debt to society. However, they are confronted with what I call the prison after imprisonment, a plethora of seamlessly endless obstacles and impediments which stymie successful reintegration into society. A vast infrastructure of barriers, often legislatively mandated, continue to erect seemingly insurmountable roadblocks at every turn, creating a host of prescriptions blanketed under a one-shoe-fits-all regime. It is also important to consider such collateral consequences in the context of particular populations like juveniles, who may be especially vulnerable to denied opportunities, and people of color who are disproportionately represented in the criminal justice system. Furthermore, non-citizen defendants can face immigration consequences so serious that the Supreme Court recently recognized this issue. What types of collateral consequences do defendants face, and how should they factor into the advice that defense lawyers give? How should the president's or a governor's pardon power figure into addressing unfair and lingering consequences of a conviction? What other efforts are being pursued to address these issues? Our panelists today will provide thoughtful insight on these and other questions. Just before I introduce them, I want to remind everyone to turn off those cell phones, okay, or put them on silent as this session is being taped. And also for the panelists, if you can actually put your phones on silent so that the microphones don't feed into that. The panel will be in the form of what I call a guided discussion, wherein after I introduce the panel, I'll propose a question to each of the panelists who will provide a response no longer than about 5 minutes. And after our discussion back and forth, at the conclusion, we'll open it up for Q&A. So you do have the bios of the panelists in your folder. So what I am going to do is just provide a few highlights into their illustrious backgrounds. First, we have Congressman Bobby Scott, who serves as the ranking member on the U.S. House of Representatives Crime Subcommittee, a member of the Subcommittee on the Constitution and the Committee on Education and the Workforce. During his nearly 20 years, it's been really about 18 years in Congress, he is known as a strong and staunch defender and champion of the Constitution and the Bill of Rights. It was his leadership in the House which finally brought movement towards the elimination of the disparity between crack and powder cocaine, and his passion for juvenile justice reform and crime prevention legislation has resulted in his introduction and promotion of the Youth Promise Act. We next have Judge Lynn Adelman, who is a U.S. District Judge for the Eastern District of Wisconsin. And as a judge, he has been the author of many influential opinions on federal sentencing, and he is widely published on sentencing, federal habeas corpus, and extremist speech on the internet. Prior to his judicial appointment, Judge Adelman was a legal aid scholar, legal aid society lawyer, and also argued many cases before the Wisconsin Supreme Court, as well as Wisconsin versus Mitchell before the United States Supreme Court. He also served for 20 years as a Wisconsin state senator, where he chaired the Senate Judiciary Committee. I would next like to welcome Cynthia Jones, who is a professor of law at the American University Washington College of Law, where she teaches courses in evidence, criminal law, criminal procedure, and the popular seminar, Race, Crime, and Politics. She serves as the director of the American Bar Association's Racial Justice Improvement Project and as chair of the Board of Trustees of the DC Public Defender Service, and also on the board of the Innocence Project. Professor Jones is the writer and producer of an animated short film on the federal rules of evidence, for which she was awarded the Teaching with Technology Award. And next we have Yolanda Vasquez, who is a clinical supervisor and lecturer at the University of Pennsylvania Law School. Her specialty areas involve the incorporation of immigration law into the criminal justice system, known as crimmigration. She also assisted with the seminal Supreme Court case Padilla versus Kentucky on the issues. She also studies how crimmigration affects the Latino community, arguing that it has become the primary means to subordinate and socially marginalize Latinos. And last but not least, we would like to welcome Melvyn Weiss to the panel. And I'm looking over Mr. Weiss's bio, and I'm saying, a mediator in complex mass tort litigation, addressed national and state accounting and auditing boards, a leading authority on shareholder and consumer rights in the national media, named as one of the top 100 most influential people in the field of accounting. But then I get to the clincher. Mr. Weiss recently served a 30-month term for paying portions of his firm's court-awarded fees to the firm's clients in class actions. And in addition to paying $10 million in fines and penalties, he lost his license to practice law and is currently serving 3 years of probation. So perhaps out of everyone on this panel today, Mr. Weiss perhaps has more than textbook knowledge of collateral consequences. He is living them every day. And as a note to you, previously scheduled panelist Pat Nolan, Vice President of Prison Fellowship, was not able to join our discussion today. Very, very, very much the family man. Mr. Nolan is attending graduation events with his son, and he deeply apologizes for his absence. I just wanted to acknowledge a couple of people in the room right now. I see Ted Shaw, who is on the board of the American Constitution Society and former director of the NAACP Legal Defense Fund. We would like to welcome you. And I also saw walk in none other than the Dean of the Congressional Black Caucus, veteran Congressman John Conyers, the ranking chair of the House Judiciary Committee. Welcome, Congressman Conyers. All right, so let's get started. Congressman Scott, let's start with you. Stalwart champion up on the hill of just about any and everything progressive that has ever passed up there. But in 2008, you celebrated the enactment of the Second Chance Act, the historic Second Chance Act, I might add, which advances reentry programs for previously convicted people through grant funding. Can you tell us a little bit about the Act's success, as well as any of the issues that remain for previously incarcerated people, as well as the status of anything connected to that you would like to share within the next 5 minutes?
Well, thank you, Nkechi, and it's a pleasure to be here with the American Constitution Society, and also a pleasure to be here with my colleague in Congress, John Conyers, and other people who are interested in the Constitution. The panel today on collateral consequences to convictions of crime is an interesting issue and has to be put in perspective of the general debate about criminal justice issues. I've been a legislator, I've been a congressman for almost 19 years now, and I was a state legislator before then. And during that time, I have noticed that you really have a choice when you talk about criminal justice policy, and that is whether your goal is reducing crime or playing politics. Now, we're good at both, but you have to decide what you're doing. If you're trying to reduce violent crime, we know how to do that. You invest in young people to get them on the right track and keep them on the right track. You start very early. You start, in fact, with teen pregnancy prevention, so fewer babies are born into dysfunctional families. Then prenatal care reduces mental retardation, learning disabilities, early childhood education, after-school programs. Get them on the right track and keep them on the right track, and make those investments. You'll get young people on the right track. They don't get in trouble. That's how you reduce crime, and most of those, by reducing crime and other social pathology, you end up saving more money than you spend. We also know how to play politics. That's the emotional approach. You talk about mandatory minimum sentences, 3 strikes and you're out, abolish parole, and if you can get it to rhyme, it's even better. If you do the adult crime, you do the adult time. Now, all of those have been studied, and either they do nothing to reduce crime or waste the taxpayers' money. One little slogan I like is, no cable TV in the prisons. You can just imagine the cable guy showing up, disconnecting the cable, and everybody saying, phew, now we're safe. These slogans and sound bites have done nothing but increase the incarceration rate to the point where the United States locks up a higher portion of its population than any country on earth by far. And just to show how ridiculous it is, we have a chart here. All those little green bars are incarceration rate, 50 to 200 in most of the countries in the world. One of the high bars, Russia, is about 600 and some per 100,000. The blue bar, United States, #1 in the world, 700 and some per 100,000. But those purple bars, the first one is the average African-American incarceration rate over 2,000. 4,000, 10 states lock up African Americans at the rate of about 4,000 per 100,000. Now, this is significant because the Pew Research Center says anything over 500 is actually counterproductive, that you inject more social pathology in a community than you're bringing out. So if you just look at what we are spending in codifying slogans and sound bites, you can see what the incarceration rate is. And it's not free. If you take the next chart, if you reduce those 10 states that are locking up 4,000 per 100,000, and just go through the back of the envelope arithmetic, you reduce 3,500 people that are there being counterproductively held incarcerated at about 29, 30,000 a year. You will see that in a community of 100,000, you're wasting about $100 million in counterproductive incarceration. Community of 100,000. And then if you just do the back of the envelope and aim that money at 1/3 of the children who are at risk, you see you are spending that in counterproductive incarceration, where you could have spent, for every at-risk child, $10,000 per child per year in getting them on the right track and keeping them on the right track. And so we make those kinds of choices, but we need to focus on an intelligent policy. That's why I've introduced, and Nkechi mentioned the Youth Promise Act. That's a program that requires a community to come together to have a comprehensive, evidence-based program to reduce crime. We say comprehensive and evidence-based as opposed to what? As opposed to the slogans and sound bites that would be codified if you didn't put that in the bill. And come up with a program that will actually reduce crime. You also want to find out who's going to be saving the money so they can chip back in to keep the programs working after they're funded. We know those comprehensive programs work, and we know they've saved money. You've got programs all over the country that have proven that. Instead, we're doing the rhetorical, simple-minded slogans and sound bites, and when you get to collateral consequences of convictions, you can see some of these things were not subjected to a rigorous, intelligent, deliberate thought process. First, you lose your right to vote. What does that have to do about crime? I mean, what are we protecting ourselves from if people can't vote? It has no deterrent effect. Nobody's going to say, well, I would have robbed the people and only get 20 years, but when they said I wouldn't be able to vote, that's what I said, oh, no, I'm not going to rob those people. We need to make sure that we look at that. It has no beneficial criminal justice. It does have significant political effects because in some communities, a substantial portion of the African American community can't vote, can't participate in decision-making processes because of felony convictions. We also know that education is important to criminal justice issues. The more education you get, the less likely you are to commit crimes. And here we are denying educational benefits for people on an irrational basis. If you get caught with little drugs, you can't get a student loan. However, if you rape somebody or drunk driving or anything else, murder somebody, you can get a student loan. Doesn't even make any sense. But you're denying education and therefore increasing crime. The jobs, if you have a job, you're more likely to be able to avoid crime in the future. And here we are denying barber licenses and things like that to people who have been convicted. Sex offender registries make it impossible for people to get jobs. If you're in that registry, you're not going to be able to get a job. And we're not protecting anybody because most of the people in child sexual offenses either know the person or they're a total stranger from somewhere far away. You wouldn't even notice it on the registry. These things do nothing about getting people getting people back on the right track, but we make it impossible for them to get jobs. And so what Congress is trying to break through the fog and trying to have an intelligent discussion. Last Congress, we did have a hearing and tried to notice some model statutes in terms of what you should be doing on collateral consequences. The ABA has recommendations, and we need to make sure that we consider these in a thoughtful, deliberate fashion so that we can actually reduce crime and not just play politics. And Nkechi, that's why this session is so important.
Okay, thank you so very much, Congressman Scott. Out of those 700,000 people who are returning to society each year and facing this plethora of collateral consequences, many of them have been incarcerated under this country's mandatory minimum laws. Judge Adelman, though we are currently living in a post-Booker world where judges have been provided greater discretion in sentencing, can you let us know what problems with mandatory minimums remain and a little bit about the intersection between sentencing and collateral consequences?
Sure. First of all, I want to thank ACS for this panel and having me participate in it. I also wanted to add something. Congressman Scott was talking about slogans and sound bites and how much of a role they play in criminal justice legislation, sadly. He might also have added that it helps if you name your bill after some victim. That also is very important. The Megan's Law or the Adam Walsh Act. And it really is a problem because it's just a hugely important subject that really harms so many people unjustifiably, and yet it's so terribly politicized that it's very hard to bring sort of rationality to the subject. And I congratulate Congressman Scott for being one of the few people in Congress that addresses this subject in that way. Let me try to respond to the question. Booker was the case about 6 years ago when the Supreme Court made the federal sentencing guidelines advisory. And that was a hugely important case because it really gave judges a chance, in many cases, to impose fair sentences. The guidelines really, when they were mandatory, you were pretty much stuck with them. There was almost no way to get out of them. And there was rigorous appellate review of any deviant district court judges. And so by making the guidelines advisory, really, it restored, the Booker case really restored to judges the chance to impose fair sentences, to give probation when it is warranted, to give house arrest when it's warranted, to not impose excessively long sentences. So Booker was a huge deal, and all the Supreme Court's decisions since Booker have really been good. And this is maybe one of the few areas where the Supreme Court, when they first decided Booker, there was a big debate about what it meant, and did advisory really mean advisory, or was that just kind of a wink and a nod? And in all the subsequent decisions since then, the Supreme Court has said, we meant it, and if judges can explain what they're doing when they sentence somebody, they can pretty much do anything they want as long as it's reasonable. And so that's been a hugely important development. But you don't really want to overstate it because there's so many remaining problems. One of which Nkechi mentioned, and that is there's lots of cases where the guidelines don't apply because they've been supplanted by Congress's imposition of mandatory minimum sentences. And in those cases, judges have no discretion. There's lots of them. Most of the drug cases, which are probably the main staple of the federal judiciary, are cases where they're mandatory minimums. And what they do is they just create huge, they essentially leave the sentencing decision to a large extent in the hands of the U.S. attorney, because the charging decision then becomes the sentencing decision. Because if they charge a mandatory minimum, the judge can't do anything about it. So mandatory minimums are a huge problem, and the guidelines, just the fact that they remain in the form that they are, I would argue, are also a big problem, because the guidelines, I think, were widely regarded as in most cases, too harsh. Maybe occasionally you'll find a case where the guideline seems about right, or maybe even a little low, but in most cases, not. And to go back a little bit, the whole idea of the guidelines was that Congress was going to create a sentencing commission, which was sort of a body with expertise, and they were going to apply this expertise and come up with this sort of way of ending disparity in sentences and having this. And really that didn't happen, and I guess my position would be that it can't happen. I mean, sentencing is basically a moral decision. So if you have some body of experts, what exactly are they expert in? You know, are they expert in, it's hard to say. And anyway, when the commission was created in the middle 80s, that was a big era of tough on crime. I guess most eras fall into that category. You know, the commission really just, if you study how they came up with the guidelines, it's really sort of mind-boggling. I mean, it's not much different than sort of picking numbers. They essentially abolished, the idea was they were going to look at all past sentences and come up with averages and do it in a very sophisticated way, and they didn't do that. Basically, they decided sort of just a priori they're going to eliminate all previous sentences of probation in terms of calculating the guidelines. So half the federal sentences before the guidelines went into effect in 1987, half the federal sentences then were probationary sentences. So then they just eliminated all those. So now there's almost no probationary sentences in the guidelines. And the guidelines, even though they're advisory, you know, judges are human beings, and when they see a lot of factors, and one of the factors is the guidelines, you're still supposed to calculate the guidelines and consider the guidelines when you sentence. And if there's a lot of factors that are kind of vague and general, and then there's one factor that's a number, which is the guideline, and the guideline is 57 months, the judge might, I mean, it's just human nature. Judges are going to probably not vary too much from that. So just by the fact that you have guidelines and that they're the only number in there, it still leads to, I would argue, a huge number of sentences that are too long. And there's just so many people, as Congressman Scott said, there's so many people who are in prison for really a long time, way longer than is necessary in many cases. And then you know, so that's your sort of sentencing problem, and then,
Judge, I'm going to allow you opportunity to expound on that.
Am I going to?
No, it's part of our second round. I'm going to have you pick up at that point. So we're going to put a plug on that, and then we're going to make the connection between that and collateral. So thank you so very much, and we're going to get to our second round in just one moment. But I want to go to Professor Cynthia Jones right now, and with 1 in 3 Black and 1 in 6 Latino boys born in 2001 at risk for imprisonment during their lifetime. Wow. You know, the racial disparities in the criminal justice system from arrest to release are staggering. How do we respond to this crisis, and, you know, which in some cases actually are the result of the cradle to prison cycle, pipeline?
Absolutely. I teach a course, as Nkechi mentioned at the outset, called Race, Crime, and Politics. And on the very first day of the class, I always say that the course should be renamed Race, Crime, and Politics, Not a Good Mix. No good ever comes from bringing those three things together, right? The Duke lacrosse rape case is sort of the perfect storm of bringing together race, crime, and politics, and the result is always injustice, right? Lynching was the result of race, crime, and politics coming together. We have too much of that in the criminal justice system, race, crime, and politics intersecting. It is impossible to talk about crime and talk about being smart on crime and not also talk about race. The criminal justice system is run by a series of discretionary decisions, from the initial decision of who to stop and who to arrest and who to search, all the way through whether you're going to get bail, what sentence will be imposed, and what length of probation. All of those are discretionary decisions by, I would submit, well-intentioned, smart, intelligent people trying to do the right thing. But we're human beings, and we bring into the criminal justice system our biases. And those are going to be reflected in discretionary decisions. So one of the things that happens, not surprisingly, is when you have African American and Latino children, and he's talking about juveniles and adults, coming into the criminal justice system at a higher rate, searched at a higher rate, arrested at a higher rate, prosecuted at a higher rate, you inevitably are going to have that same disparate impact on those vulnerable populations in terms of collateral consequences. And as Congressman Scott mentioned earlier, the kinds of collateral consequences that affect them are so profound because race and poverty and crime and all of those things are so inextricably intertwined. You are not really likely to be affected by public housing restrictions and student loan restrictions if you're wealthy. So those are going to have a devastating impact on anyone from those populations who are trying to pull themselves out from under the weight of a criminal conviction. So some of the collateral consequences might very well make some sense for some period of time, but to make them permanent, once you've been convicted, you can no longer get a license, especially when you cannot get a license to do the very thing that, as part of reentry and rehabilitation, we trained you to do in prison. That is, you spent time in prison learning how to cut hair. You spent time in prison learning how to work in the workplace as a skilled laborer. And then when you come out, the state laws say, no, because of your criminal conviction, you cannot do the only thing that you know how to do, and you can't get a job. And then we expect that person to be rehabilitated and successfully reintegrated back into our society. So the problem we have is one of laws that need to be changed and one of policy. The policy decisions, there's no boss of the criminal justice system. There's no one person who controls it. It is run by a series of very powerful entities. The prosecutor has absolute discretion on whether to charge. The judge can't overrule the prosecutor, and the judge has absolute discretion, when there's not a mandatory minimum, on what to sentence. The police officers have discretion on who to arrest. And the smart thing to do is to figure out how you can bring those discretionary decision makers together to come up with smart policies that don't result in the over-criminalization and the over-prosecution of African Americans and Latinos. I direct a project for the American Bar Association called the Racial Justice Improvement Project, and the goal of the project is to try to eliminate biased decision-making, or at least reduce the impact. So to that end, we bring together in 4 jurisdictions through a federal grant the chief judge of the criminal court, the chief prosecutor, the chief public defender, the chief of police, and a community group working on judicial and criminal justice reform. And we talk about what disparities exist in their jurisdiction and what policies can be changed to better improve or eliminate the disparity. For example, in Delaware, they determined that African Americans were being revoked on probation at a higher rate than their similarly situated white counterparts. That's a policy decision made by probation officers. It's not a legal decision. And so they are training the probation officers on how to engage in bias-free decision making, and they are actually going to curtail their discretion. They're going to enact reforms that will prohibit them from engaging in that form of discretionary decision-making, which in effect will reduce the collateral consequences of criminal convictions on vulnerable populations. So I think we need to, as we begin to talk about collateral consequences, figure out how we prevent those collateral consequences early in the criminal justice process through all of the discretionary decisions that are made along the way.
Okay, thank you so very much. Professor Vasquez, in 2010, in Padilla versus Kentucky, the Supreme Court recognized that failure to provide adequate advice to non-citizen defendant clients in immigration consequences like deportation may amount to ineffective assistance of counsel. As part of the work on that case, you argued that while criminal convictions are dramatically increasing the number of non-citizens removed, this relationship raises serious questions concerning the role of courts and the duties of lawyers. Can you tell us about this decision and what it means for all actors in the criminal justice system, from defense attorneys and prosecutors to governors and the president?
That's a big question. I'll see if I can fit it in 5 minutes. It's interesting. Everybody has talked before me and gave talks about sound bites, and that there are certain things that do nothing to reduce crime, and it's a waste of taxpayers' money, and the connection between race, crime, and politics. And that is exactly what the incorporation of the immigration law and its enforcement into the criminal justice system is. And so when I look at the decision in Padilla, which gave a duty, a Sixth Amendment duty of defense attorneys to advise as to the immigration consequences of a criminal conviction, I actually hope that it has a larger sort of purview into the criminal justice system, in which we start to actually look at the criminal justice system and how defense counsel, as well as the courts and prosecutors, work to dispose of cases, right? Probably even how they get cases and then dispose of cases. As you know, prior to Padilla, we substituted, and probably still do, substitute efficiency for really looking at a just outcome. And so for many, as you know, the Sixth Amendment, you could be drunk on drugs, not even present, and still not be violating the Sixth Amendment. And then came down Padilla, and before that we saw a little bit more bite in a Sixth Amendment, first on the death penalty cases of Wiggins, Rompilla, and Williams. And it was Padilla that then began to hopefully say, this is not acceptable, right? Although you may say that these are collateral consequences and not important to the outcome of the case, it's important to your client, right? And really, when you're representing a client, whose goals are important, right? And obviously, I would hope that it's the client that you're representing who should be able to dictate what it is that they want in an outcome of a case. And so I'm really hoping that we take this time to be able to look at defense counsel, and as defense counsel, start to think about what really is our goal in the criminal justice system, or our duty in the criminal justice system. And on a more expansive note, how can we change either law, legislation, professional ethics to be able to make sure that we can maybe possibly have to force some people in doing what it is exactly that we would like them to do. When we talk about prosecutors and courts, as you know, no one wants to get rid of a plea. The courts don't want it to come back, and prosecutors don't want it coming back either. And unfortunately, what we've seen in light of Padilla is that across the country, courts and prosecutors are finding ways in order to, again, circumvent sort of Padilla, what that means, and trying to ensure that the plea sticks. And in Arizona, for instance, big surprise, it's Arizona, we see the prosecutor actually putting into their plea agreements that they have to waive Padilla, right? So we get the Sixth Amendment right, and then the prosecutors try to take it away instead of actually thinking, you know what, we can preserve a plea if a defendant really knows what he's pleading to. Right? And if we can do that, then maybe we won't have people coming back and trying to withdraw their plea. Now for state actors, for governors and the president, this is also, I think, really important because I think it goes to the fact that we really need to stop going into the rhetoric and the sound bites. And we really need to start refocusing this conversation to what immigration consequences are in the criminal justice system, right? We hear about, you know, how all these programs, 287G, Secure Communities, Operation Streamline, they're all used to combat, make our country safer, right? National security, protect our borders, make our community safe. But when you look at the results, the only thing that it's doing is actually deporting people who are driving while brown, right? It's drug crimes, traffic violations now, and immigration violations represent 66% of the people in this country who are being removed. When you look at the statistics to actually try to look at the violent crime or terrorists, it actually doesn't really exist. For instance, terrorism, murder, sexual assault, none appear to be the leading or even considerable cause of removal. Sexual assault offenses account for only 2.2% of the total number of immigrants removed for criminal violations. Terrorism and murder do not even appear on the list. So again, we really need to start thinking about how the rhetoric and how the president and other administration is looking at this, and instead of doing enforcement only, right? Even under the Obama administration, the 7th consecutive highest amount of removals, total and removals for criminal conviction has existed, right? It's enforcement only. And with enforcement only, we're only looking at people and saying, those are criminals, those are dangerous criminals, we need to get rid of them. Instead of really thinking about what is really happening, which is, we're not reducing crime, we're wasting taxpayers' money, and terrorism and national security is not an answer in any of this. So hopefully that is something that we can start thinking about.
Thank you so very much. And now I'll move to Attorney Weiss. You know,
Former attorney.
okay, okay. Prominent and successful attorneys are not who you would typically think of when discussing the previously convicted and the incarcerated population. However, you were recently released from incarceration and faced some of the collateral consequences that all previously convicted people face. What resources, both external and personal, have been critical to your reintegration? What obstacles do you face? Talk to us a little bit about your personal experience.
Well, really, my personal experience isn't as relevant as the personal experiences of the people I was incarcerated with. And, you know, I spent almost 50 years practicing law, representing victims of wrongdoing, but in a totally different type of activity, stock fraud, you know, things like that, antitrust litigation, consumer fraud. And all of a sudden, I'm thrust into an environment where approximately, I guess, 85% of the people I was in with are minority people, you know, African Americans, Latinos, and they came out of environments like the Hood. They called it the Hood projects, and I learned an awful lot about that life. And that's really what I want to talk about. I mean, just take me as an example. What program am I on today? I'm on a program dealing with consequences of criminal convictions. Across the hall is a program about securities litigation, which I only practiced 50 years of, and headed probably the biggest law firm in the history of the world that dealt with those kinds of issues. So, as a matter of fact, my introduction doesn't even mention that. It talks about I'm on the 100 most important people in the accounting profession. But the thing that I want to deal with is that unless we deal with what Congressman Scott spoke about, and that is preventing these people from getting into the criminal world, we have to reinvent what we're doing with the ones that are in there now, because they're not prepared to come out. As an example, they come out into a halfway house, and I remember getting a brochure about the halfway house I was going to go into. It looked wonderful. It looked like Nirvana. It had a gym. It had an outdoor patio. It was described in the most flowery ways. When I got there, you know what it was? It was a Salvation Army building that was decrepit. There were piles of yellowed, what should have been white-page telephone directories just piled helter-skelter all over the place. There was one little television with rabbit ears in this day and age. The gym had basketballs that you couldn't even bounce. The rim was crooked. The outdoor patio had chairs that were falling apart. And I walked into this environment, I said, how is this supposed to be a transition into society? Okay? I stood by the desk. One of the inmates came down for a pass to go to find a job. So he wanted a ticket to get on a bus because the job seeking was 5, 6, 8 miles away. Did you get permission from your counselor? Well, nobody told me I had to. Well, then you can't get a pass to go on the bus. The kid had no money. I mean, it was one thing after another that made it almost impossible for these people to reinvent themselves and to go into society and to be productive, facing the most horrific kinds of challenges. I mean, after all, most of these people were in the drug dealing business because that was a business that they learned in the hood, in the projects, or wherever they came from, and they were supporting their families, probably fairly decently, although a lot of them had no fathers because they were abandoned, and they had baby mamas, not spouses. But there was an expectation when they came back they were going to fulfill the role of being the man in the family. And how were they going to do it? They couldn't get jobs. There was nothing in the halfway house transitional period that really helped them do that. And I have to tell you, it broke my heart. And then when I got out from the halfway house and out of the home confinement period, I found out that I can't talk to any of them. I can't talk to any of the people I met inside who I became friendly with and who depended upon me for a lot of things because I was Poppy. I mean, I was so much older than everybody else. I'll be 76 in August. I guess I was 73, 74 when I was in there. And I was their father figure in a lot of ways. And then I'm told, while you're on probation, you can't have any contact with anybody who was a felon, no matter when they committed a felony, even if it was 40 years before. And these young people would try to get in touch with me so that I might be able to do something, helpful in their lives, and I can't do it. I'm supposed to get permission from the probation officer, but forget that. So, what does it take? It takes friends and family. But think about the friends and family that these people left behind. They were in an environment that wasn't very healthy. For me, I had a very healthy group of friends and family, so that wasn't an issue, okay? I mean, it's a stigma that you never can shake. Ex-cons, this is today's paper, ex-cons floated as laborers. I once tried a competition among my fellow inmates. What's a good way to describe us once we serve our time? Okay? Other than a felon or an ex-con or a criminal. You served your time. And then what do you become? An economic prisoner, because most of them have fines and penalties that they have to pay. And how are they going to pay those fines and penalties when they can't even get a job? And every time you fill out a form on probation every month, you have to talk about your income and the job and what you owe them, the government. Congressman, cancel those debts, just like in a bankruptcy.
Yeah, thank you so much. This is, you've really said a lot, and I think your presence on this panel helps to speak volumes to this issue as well. I want to go back to Judge Adelman right now and give you the opportunity to complete your thoughts that you were speaking of earlier, but also in the process, if you can also let us know or describe for us what ways in which criminal justice actors can minimize collateral consequences, whether through charging and pleas or expungement and sealing of criminal records or diversion or other alternatives. So you can go on and go on and continue.
Well, in the federal system, there's really not too much that can be done. There's really no federal expungement statute, and I don't think I've had since I've been on the bench, I don't think I've ever had anybody come in and ask to expunge their record. Apparently, there are a few circuits that have sort of suggested that maybe there's some possibility that courts could do it, but the courts that do it, it's so rare that it's virtually non-existent. And that really is something that could be studied by Congress or by the Sentencing Commission, because expungement would be one way of minimizing collateral consequences of jobs. If you could either give the judge discretion to expunge right at the time if he didn't think that the act that was criminal was so serious that it required these collateral consequences, or you could sort of say that the person could come back after a year or 2 years or something of being law-abiding and get it expunged then. But that doesn't exist now. You know, one thing we can do, and this sort of goes back to Booker, a lot of defendants, you'll know that they're going to be subject to really serious collateral consequences. Deportation is one. Say somebody's coming before you for sentence, and you know they're going to be deported. Or another, I had a case recently of a funeral director. It was a child porn case, those are becoming very, very common. And so he's going to lose his license. That's the end of his funeral business. Child pornography is a case where you find a lot of people that have these licensing problems, like they're going to lose a license of some kind upon which their income depends. The only way I can do anything about that is to take it into consideration in imposing the sentence and impose a lesser sentence, because you know that's going to be a subsequent penalty. We're starting a reentry court in the Eastern District of Wisconsin, which is to try to make it easier for people that come out of prison to, it's sort of a very rigorous form of probation and supervision to try to help people along with sort of being able to, maintain a life in the community. But really, there's very, very little that a federal judge can do. Sometimes you can work a plea. Sometimes you can, if somebody's going to have an immigration consequence, you can maybe, and the prosecutor has a huge role in this, maybe the defendant can be allowed to plead to something where it won't be so certain that they'll be deported. Because it's very vague as to what offenses call for deportation. And some do and some don't, and it doesn't seem to be a very clear line. I think moral turpitude is one standard. So sometimes you can do a little bit with that, but really there's very little I can do. And the main collateral consequence, I mean, there's licensing and so forth, but the main collateral consequence is just the difficulty of getting employment. There was a study in Milwaukee, actually, where they took felons and they did send out testers, like in the housing, where they sent out for housing discrimination. They sent out testers to apply for jobs that were advertised. And they sent out whites and blacks in equal amount, and there were very few callbacks for jobs after interviews for any of them, but the number of callbacks for whites were double the callbacks for blacks. So there's really serious consequences that me as a judge and really nobody in the federal system as it works now can do anything about.
Yeah, thank you so very much. You know, in that very study that you mentioned, I think it even went so far as to say that the callbacks for whites with a criminal record was greater than the callbacks for blacks without a criminal record. I mean, that speaks volumes also in terms of the racial disparities in the whole system as well. But Congressman Conyers, attorney, Congressman,
I appreciate the
I was looking to
compliment.
see if he was still in the room. I'm sorry, Congressman
I appreciate the
Scott.
compliment.
Congressman Scott, I was looking to see if Congressman Conyers was still here too, because I was going to address him as well. But Attorney Weiss issued the call or the challenge to Congress to do something about those debts that formerly convicted people face, to do something about that box, the box on the employment application, have you ever been convicted of a felony, to do something about maybe a federal expungement bill or sealing record. Tell us what prospects, if any, are there out there in Congress or even bipartisan?
Well, the first challenge is to get into a posture where you're actually deliberating. As the judge indicated, every good politician knows that you should never vote against a crime bill named after somebody. And so however ridiculous the provisions are, if it's named after somebody, you vote against it at your peril. So getting into deliberation, and then the process doesn't really allow deliberation. We had a gang roundup where one gang leader got 50 years. There's no point in the deliberative process where $30,000 each, that's $1.5 million. The judge essentially appropriated $1.5 million. Should he have appropriated maybe $500,000 rather than a burst of incarceration, rather than $1.5 million, particularly in light of the fact that that same city is cutting back funding for Boys and Girls Clubs? There's no choice or balance in those kinds of decisions. And then what effect do the collateral consequences have anyway? You've got juveniles guilty of consensual sex offenses now on a registry that will affect them for the rest of their lives. I mean, what is the criminal justice policy benefit of that? And so we've got second chance programs that we did get a consensus on. One of the factors there is that so many people released from prison, and there are hundreds of thousands, 800,000 people being released from prison, without any kind of intervention, we're expecting about 2/3 of them to come right back. And at $30,000 each, the economic reality is setting in when some of these second chance programs can reduce recidivism from 2/3 down to 10%. And if you look at all the money that you save there, if you don't care about the humanity, if you don't care about the crime rate, if you don't care anything about just the budget, it is a compelling case just on the budget. So we were able to get a consensus for second chance programs there. We passed great legislation. Unfortunately, we haven't gotten great money. It's just a 20, 30, $40 million. We may get it up to 100. The program really needs to be in the billions because that's the kind of money we have the potential of saving if we properly fund these programs. So the challenge in all of this is to get people to actually sit down and think about what they are doing. And as we've had, when you've got race, politics, and crime all roped up together, and particularly the political part of it, it's just hard to get people to deliberate when a soundbite can run 60, 70, 80% in the polls and at the same time increase the crime rate. There are very few politicians that will jump on the 20 or 30% side of that debate.
Professor Jones, you sit on the boards of both the Innocence Project and the Public Defender Service. Can you tell us about the impact with respect to collateral consequences on those who might have been wrongfully convicted and incarcerated, as well as the intersection between indigent defense and collateral consequences?
Absolutely. In many jurisdictions across the country, people have been wrongly convicted, and with DNA evidence, they've been exonerated. In other jurisdictions, even with DNA, or in instances where there was no DNA available, but everyone in the criminal justice system agrees the person was wrongly convicted, they can be subject to a pardon. They can be simply released from prison, though not exonerated. The case of Thomas Hainsworth, a recent case in Virginia, is a good example of that, where the prosecutors came back and said, yes, we agree that the evidence suggests he's innocent, but he has not been exonerated. He still lives under the weight of the collateral consequence for a crime that everyone agrees he did not commit. And so across the country, we begin to see people who've been wrongly convicted but not thoroughly and completely exonerated, still living with the collateral consequences, and it's a heavy burden, especially in Mr. Hainsworth's case, where you've been incarcerated for 27 years. You already have a significant or a lot of explaining to do in your resume, and then to add to that sex offender registration for a rape you did not commit. The indigent population in the District of Columbia and across the country, again, they're going to face the brunt of these collateral consequences. There are things that the defense bar would have to inform a defendant of that could number in the thousands. The American Bar Association has a project where they are documenting the collateral consequences of criminal convictions in every state across the country. They have found over 40,000 collateral consequences. That is everything from juvenile convictions or juvenile adjudications to adult populations, voting, jobs, parental rights. There are so many collateral consequences. It would be almost impossible for the defense attorney to say, if you plead guilty to this, you might be deported, you might lose your kids, you may not in the future be able to apply for the military, you won't get student housing, you won't get this, you won't get that. It would be impossible. It is critical and now constitutionally mandated that you inform your client of immigration consequences, but there's no line there. When does it stop? How much do you have to be aware of before you can legitimately say this was a knowing and intelligent plea and I understood the collateral consequences? So both populations, the people who've been wrongly convicted as well as the people who are simply poor, are going to face a tremendous burden of dealing with these collateral consequences. There is help on the horizon in terms of at least knowing what the collateral consequences are. If anyone's interested, the American Bar Association has 2 different websites, and it should be easy with a Google search to find either. They have already completely developed a database on juvenile collateral consequences, including providing notification cards to juveniles to say, these are the collateral consequences of your conviction. If you plead guilty, you are likely to not be able to get student loans and those kinds of things. So it's an intelligent decision and easier for a defense attorney to inform their client of the collateral consequences. They have already completed a database to document each collateral consequence in every state, and they eventually, by the end of 2012, will make it searchable by crime. So you simply put in the code section of the crime your client is being convicted of, and it will generate a list of all of the collateral consequences for that crime. That project is currently underway. But the bottom line is, it's huge. It's huge, and it is ridiculous, as Congressman Scott said, to simply say you cannot have a license to practice the field you're trained in, or you cannot get public benefits, or your grandmother cannot live in public housing because you were arrested in her house and convicted, and she didn't do anything wrong, and you could lose custody of your kids, on and on and on and on and on. You make it virtually impossible for anyone who's been convicted of a crime to successfully reintegrate back into society.
All right, thank you so much. I mean, it's just listening to what you're saying in terms of the number of collateral consequences that have been indexed by the ABA. I mean, it's really mind-boggling, and many people don't realize that that is what is going on here every single day. So I'm glad that the ABA does, in fact, have that report. And I remember when I first started looking at this issue in the late 90s, it really wasn't too much on the radar screen, and I began to talk about some of these issues as part of presentations, and people thought I was really coming from out of left field, shall we say. But now it is becoming more mainstream in terms of knowing what is out there, and now we're at the point of just what can we do about it. Let's go to Ms. Vasquez right now. Can you describe for us the impact of collateral consequences on the Latino community?
That's a really big one. Let me just give you some of the numbers overall, and we can put it in perspective. I want to talk about, in the 1980s, in 1988 actually, the number of people who were removed was only 25,829, and 5,900 of those were removed based on criminal convictions. In 2009, 393,000 people were removed from the United States totally, and out of those, 128,000 people were removed for criminal convictions. You can see that the numbers are just out of control. And in 2010, I think we've hit over 400,000, and I know, again, it's been probably closer to 140, 150,000 who were removed. As you know, Latinos currently represent the largest minority in the United States, representing approximately 15.8% of the US population, and they're also the largest immigrant group, right? They represent 53.1% of the immigrant population. When we look at the number of people who are removed or where they are from, actually the majority are Latinos, right? The majority of non-citizens being removed are from 5 Latin American countries: Mexico, El Salvador, Honduras, Guatemala, and the Dominican Republic. In fact, in 2009, 94% of the total number of individuals removed were Latino. And 94% of the individuals removed for criminal convictions were also Latino. So you can just imagine the impact that the immigration consequences of criminal convictions is having on the Latino population. Not only the individual who's being removed, right? Because obviously when they're removed from a country, many are here for a number of years. They go back to a country they don't know. They may not even speak the language. They have an inability to be unemployed. If they were lawful permanent residents and were removed based on a criminal conviction, they lose all Social Security benefits, right? When you look at actually Latinos who are United States citizens are also being affected based on racial profiling. There's a research that was just done that says 1 in 10 Latino Americans were stopped by police and asked about their immigration status. For example, at Alabama, based on 287G, about 58% of people who were pulled over by one police officer were Latinos, even though Latinos represent only 2% of the population in Alabama, right? So when we look at racial profiling, that's also devastating. But we also have to think about their families, right? We have to think about the children and their wives. Many are the main bread earners, right? So if you take them away, there's, poverty is affected, right? The stress of being either left behind or going back on children is unbelievable. Those who, I know in many of the raids that were taking place during the Bush administration, and especially agro-processors, the Iowa Postville raids, many were taken then because both parents were put into deportation proceedings. Some went into foster care, right? And if children are put into foster care, they have a much higher rate of pregnancy, being uneducated, being into poverty, and mental stress, right? When you look at what it's actually doing for communities, again, they looked at Postville, and they saw within 6 months, agro-processors had claimed bankruptcy. Actually, within about a year, the town itself was basically a ghost town. There were unoccupied houses, there were empty stores, there were mortgage foreclosures were just out of the roof. Social services did not have enough funding, because when you think about the number of people then have to ask for help, right? Because they no longer have employment, money's not coming in. And so the effects on the Latino community and the community in which they live not only is having devastating effects now, but the ramifications in the future, I think, is something that we as a society are really going to have to deal with. And therefore, again, when we look at the fact that people are not being deported because they're dangerous criminals, right, or terrorists, but people are being affected to maintain poverty and social marginalization, we really need to think about change in law and policy. And that's really what I hope that we can do.
Okay, thank you very much. And I'm going to continue to say Attorney Weiss, if that's okay. But given your immense financial background, and you all can read all about it in your booklet there, I would like for you to discuss for us, just for a bit, the fiscal impact of incarceration and collateral consequences.
Let me approach it this way. One of the things that struck me emotionally was the visiting rooms at the place where I served. I shouldn't say rooms, room. And what I saw was rules that you can't touch whoever comes to visit you, your spouse or your girlfriend or your significant other, and little kids who only see their father in this environment that's very strictly supervised. And I said to myself, what is the impact on those kids? Growing up, sometimes not seeing their father for years, except in that environment. There was no outdoor area where they could go. If a guard saw the inmate go like this to the spouse or significant other, right away they would come in and say, separate. I remember my wife gave me some money to put into the vending machine, and the inmates protected me because I was like sort of, they knew that I wasn't used to this environment, so they were going to make sure that I didn't get in trouble. No, Mr. Weiss, you can't take money. You can't touch the money. And they pulled me away from the machine before the guard would come and do something to me. I mean, it was so nonsensical in my view. Somebody said before that if they took away the, what was it, a television or something? Well, they took all the vending machines out of the gym, which we all look forward to buying a candy bar or something, during the day from. I was thankful because my job was sweeping the theater after the movie. And when they had those machines, the wrappers would wind up on the floor, so I had extra work. So, but the point I'm making is that in the visiting room, the profound impact on those kids had to be a lifetime impact. And we can do something about that, because the collateral consequences aren't, as was pointed out, just the inmate, but it's the friends and the family and the kids that these guys have to go back to, and how they're received and perceived. So at least give them some dignity while they're incarcerated, when their families come to visit. It's not that big a deal. And it doesn't cost anything because there's grounds for it. There's facilities that they can do it with. Being incarcerated is a horrible experience. I don't even care if you call it a camp. We had over 1,000 inmates, and there was a SHU, a special housing unit, which is solitary confinement. And I had to give testimony once in an incident that, one day I guess I'll write about these things, but in any event, they put handcuffs on me. They put me in a cell before I had to go and testify. For somebody, anybody that, just being incarcerated that way, I don't think you can experience, you can know what it's like until you experience it. And when you put somebody into a jail for 15, 20 years, what are you doing to that human being? What are you doing to that human being? What chance does that person have to come out in any way normal? And what for? Put them to work doing something that's meaningful, highly supervised, so that when they come out, they really have skills that they can put to work. My advice to these young people was, get a job, any kind of a job, even if it's a job that you wouldn't otherwise consider, and then prove that you can do the task well, better than anybody else, and work your way up. Even if it's minimum wage, it's better than being out on the street doing nothing. But even those jobs aren't even available. You talk about collateral consequences in an economy like today? What are they coming out to? And what do we do to help them? Let's have an economic program where they can be building roads or speed lines, railroad lines that will help us get back and forth to places more quickly. There's so many, improve the bridges, improve the infrastructure of the country. And you'll have loyal people doing it and working hard, and families that'll be proud of them. Anyway, the advice I got from most of my friends was, why do you want to dwell on the criminal part of your life? And I said, how can I have gone through that experience with the 50 years of legal practice that I experienced and not try to do something about it? So that's why I'm here.
Thank you. Just before we open up for questions and answers, I just want to pose one question for just a couple of panelists, whoever wants to respond. Attorney Weiss talked about the real life experience. He talked about the critical importance of human dignity. We talked earlier about the rhetoric and the slogans and the rhymes and the jingles, and I don't even know if we mentioned the sports analogies, 3 strikes and the like. But how do we really take this out of that 30-second soundbite and really enact meaningful changes that deal with real life experiences and promote that human dignity? Does anyone want to jump in on that? Okay, Judge.
Well, I'll just, this is anecdotal. It doesn't necessarily mean that much. I was in the state legislature in Wisconsin for a long time before I became a judge, and I actually represented I guess what you could call a pretty conservative suburban Republican-type district. And I was chairman of the Senate Judiciary Committee, and I served 6 terms, and my sort of self-appointed job was to kind of kill all the tough on crime legislation that was introduced, and that was always used in every election against me, and it never really took. And after a while, I sort of came to the conclusion that a lot of this, what you're just talking about rhetoric and tough on crime, and is sort of, to some extent, it's more in the mind of the legislator than it is in the mind of the public. My feeling was that if you talked sort of sanely to constituents and explained it, most of them understood, and there was a huge number of people that had drug issues with family members. I mean, this is really widespread, and so I found that if somehow you could get legislators to care about this more and to realize that they're not going to get recalled if they vote against the Megan's Law necessarily, or some other draconian law. That's not really the way it is, but somehow public officials don't have that mindset. I'm not sure how to change that, but I think they make it worse than it really is.
Well, one of the problems, and I still am a legislator, so I have to put up with it, is that there is no political downside to acting simple-minded and ignorant on crime. When you vote for Megan's Law, no one ever gives you a phone call. When you vote against it, you get a phone call, and like you have said, you give a rational explanation, and the problem goes away. But nobody gets a call, why'd you vote for it? Why'd you vote for trying more juveniles as adults when all the studies show that the crime rate will go up, the crimes will be more likely to be violent, more likely to be committed sooner, you endanger the children, and it's applied in a discriminatory fashion. So when I vote against it, I'm voting to reduce the crime rate. I don't suffer any political downside because I can explain it, but those who voted for it never get a phone call. And that's the challenge. We have to create some political downside. Somebody has to go to a town hall meeting and wave a flyer at somebody and say, I just wanted to know what this adult time for adult crime is in this brochure for, because everybody knows that that will increase the crime rate. Are you that stupid, or you think we're that stupid? Now, no one has ever gotten a question like that, to my knowledge, and I guarantee you, if a politician got a couple of those questions, the next printing of the brochure would have a blank space where that little soundbite and rhyme was printed. But you have to impose some political downside to voting simple-minded and ignorant on crime. If you stumble on your explanation, I can assure you that when you vote against a crime bill named after somebody, that you'll suffer.
Just real quickly, I just wanted to say, in some of what both the other panelists were saying, it's a public education question, right? We need to educate the public about this. And, someone wise said, criminal justice reform is probably one of our most challenging civil rights issues of the day, right? Until it happens to you or somebody in your family, you don't think about the ramifications until it's your son who's mandatory 5 years. It sounds like a good idea before that. It's like, yeah, he's a druggie. Lock him up for 5 years. 5 years is not enough. And then it's like, but not my child. So I think there's some public education and awareness that has to occur. And then I think the public would support these reform measures that make sense. But right now, it sounds like criminals are other. There are these other people there, and whatever bad happens to them, they deserve it. And we don't care about it. And then we start thinking, we don't actually think about how much it's costing and what it really means in terms of human capital.
Okay, last panelist comment. I think I saw your hand.
I think that media matters a lot. And I think that there's a heavy responsibility on the members of that profession to be responsible about how they talk about these issues. I mean, just as that article I showed you today, ex-cons sought as laborers. They don't have to use that kind of language, in their headline. These are people who are serving their time, paying their punishment, and they want to put them to work for the public good. By putting ex-cons in there, right away you conjure up all kinds of scare, emotions in the audience. There was another article this morning about a parolee shooting a sheriff who wrote something on his behalf to get him to be a parolee. Now, when that's built up by the press, it just scares the hell out of everybody that put people on the street who are parolees, and you're creating danger. I mean, who knows what the underlying facts there were? The guy's been out on the street for a year and a half, as I read the article, and something happened. It may be because of some very personal thing between the two of them. I don't know. But so what? I mean, it's no different than what happens in the Middle East. Who shot the former Prime Minister of Israel? It wasn't an Arab, it was an Orthodox Jewish guy, okay? So should the whole peace process fall apart because somebody shoots somebody, one person shoots another person? We've got to be responsible about how we react to these emotional happenings.
Okay. Wow. Thank you so very much, panel. Let's give our panel a big hand. It's your turn now for a few minutes. We want to open up for questions. I want you to wait for the microphone to come to you. We request that you keep your questions concise.
Hi, thank you for this panel. It's been great. I have a question. So Judge Adelman already spoke to this a bit, but I wanted to ask if any of the other panelists had anything to say about the promise or limitations of record expungement, especially in a place like California where it's tantamount to a footnote that says, this charge, which is still fully visible, has been expunged, where most employers don't know how to interpret that. So if anyone could speak to that, I'd appreciate it.
Doesn't matter in removal. Expungement still gets you deported or removed, so, fortunately.
And in many jurisdictions, including the District of Columbia, you can expunge an arrest, but you cannot expunge a conviction. So it remains a collateral consequence. It hasn't been reformed.
I think the other issue is, what does expungement even mean in this technological age? I guess that's a discussion for another
It's in
panel at
Wikipedia.
another time. Okay, next question. I'll let the microphones do the choosing.
Yeah, it seems to me that talking about collateral consequences is something of a misnomer. These are penalties. This is punishment, additional punishment, in my mind, that is being imposed on people who've been convicted of crime. And I'm wondering, those who, the proponents of such additional punishment, how do they justify it or explain it? Are they claiming that it is something other than punishment? Are they claiming other reasons for it, or do they just ignore the connection between the criminal act and then this other stuff?
Well, let me just say the question can best be evaluated on these sex registries. I mean, what's the point of a sex registry for a teenager that's been involved in consensual sex? I mean, what's the point? Then that is a real penalty, because if you're 19, a teenager 19, and get caught up with, if you're a 19-year-old senior star football player and get caught up with a 15-year-old cheerleader, all consensual, that can affect you for the rest of your life. And what's the point of that? So, I mean, you have to deliberate and get to the point to try to compel people to think about what they're doing. But there's no question, these are in fact penalties. They're imposed, they're predictable, they're going to happen, and they're collateral because they don't happen all at once. The judge doesn't do it, but it's there's no question that they are in fact penalties.
And I think it reflects the notion that once you've been convicted of a crime, you're a bad person. Yeah. And you're not entitled to all of the stuff that the rest of us get in terms of voting, in terms of government benefits. Once we've labeled you a bad person, you cannot benefit the way the rest of society can. And so all of these collateral consequences were, I think, the underlying theme is it's an effort to brand this person and isolate them from the rest of us. And we keep it going and perpetuating it because we continue to believe no matter how much time you served or how you've paid your debt to society, once you've been convicted, you're a bad person. And until we remove that stigma and that mindset, we're not going to get rid of some of the collateral consequences.
But that's even more egregious because of the incarceration, the overcharging. You're roping in so many people that it is not a stigma for a few people. Right. You've got right now, without intervention, 1/3 of black boys born today will serve time in prison. So I mean, that's not some select punishment. I mean, you're branding an entire group.
And you're not limiting it to violent people or murderers or rapists. You're saying you possessed drugs once, and it doesn't matter what else you've done in your life. It doesn't matter what else you were doing in your life. You're a bad person now, and therefore all of these consequences flow from that one action 15 years ago, 20 years ago, and they remain.
And they don't never look at the causes.
Exactly.
Let's see if we can get one or two more questions in. Microphones. Over here. Okay.
Good afternoon, and thank you for speaking with us. I was hoping to get the panel's opinion on the proliferation of private prisons, both the sort of Blackwater type concerns that come up, and also the perverse incentive that it creates where you have these private institutions that rely on a steady stream of inmates for their income.
In immigration, although crime is lowering, right? Crime rates are lowering. Actually, what they're doing is now local jails and other jails are being used as detention facilities for immigration detainees. And as you probably know, the majority of people who are in federal penitentiary are people who are in for immigration violations. Federal court now, 54% of all prosecutions in federal court are immigration violations. When we're talking about, DHS actually has the largest detention center. It holds up to 400,000 individuals. and that was spent about $1.77 billion. And so we're talking about, although we're talking about taxpayers' money, it creates jobs. And I think about convict leasing and how local communities really benefited on that. And there's an example in Ottawa County, Alabama. They were actually going to take 350 beds out of their detention facility, which was actually going to have people laid off, and they were able to stop it. So that meant saving 49 jobs and keeping the employees' buyback policy. So again, it is a major issue as far as privatization and the increase in using these beds, now local jails, actually as immigration detention. It's a money maker.
It's even an issue when it's not private. In New Orleans, one of the projects of my Racial Justice Improvement Project is looking at ways to divert nonviolent offenders from the criminal justice system, giving them pretrial diversion. The first problem we ran into was the sheriff in New Orleans who runs the jail. If you decrease the number of people who are being prosecuted, people who are being diverted, that decreases the number of amount of money he gets for the jail. So he was against pretrial diversion because it was going to have an economic impact. He's an elected official. He needs to get reelected, and he wants a bigger jail. So diversion was definitely not, even though it was good for criminal justice, it wasn't good economics for him. So you run into it in the public sector and the private sector.
There's one philosophical question about private prisons, and that is that same problem you have with contractors in the military, and that is you have delegated the use of deadly force to a private sector, a person that's not really in the chain of command of the democratic system. So that's a serious concern. But most of the over-incarceration is not as a result of the prison industrial complex. You see in isolated situations, California, apparently New Orleans, where you have a political push that's affecting policy. Most of the policy is not intentional. It's just people supporting simple-minded foolishness. The mandatory minimums, over-incarceration, the life without parole, the 3 strikes and you're out, that kind of thing, that just created that chart we had up there where you're just going off the map in terms of incarceration rate. There's no real deliberation. It's just everybody doing his or her job, creating that map. In a couple of areas, the prison industrial complex creates political pressure, but to the extent that we can apply any meaningful downside to people who are pursuing simple-minded and silly policies masking as criminal justice policy, if we can apply some political downside, that would cure most of the problem.
Okay, I'm sorry, but we only have time for one more question, but we do have 15 minutes of networking at the conclusion of this panel, where the panelists will be here to, hopefully will be here to be able to entertain individually any questions or whatever that you have. So persons with the microphone, you make the choice. Okay, you've made it already. There you go.
One very simple way to reduce crime and its collateral consequences is to reduce the number of acts that are criminal. We have this incredibly vague and expansive federal criminal code, and you can find some concern about that even on the right when it comes to white-collar crime. You can even find it on the Supreme Court. And so I'm wondering, and I address this, I guess, primarily to Congressman Scott, is it just a fantasy to think that you could actually exploit some of the right-wing rhetoric about concentrated federal power and freedom to try to expand some of this concern about the over-criminalization of white-collar crime to the over-criminalization about crimes for everybody else, including, a lot of us in this room?
It's not just rhetoric. I think there's a real push in some areas. A lot of crimes are what is called strict liability, where you are committing a crime although you didn't even know you were committing a crime, and people have found themselves in jail because of that. Recreating the traditional, what's called mens rea, criminal intent, as a condition, as an essential element of a crime, would go a long way into eliminating that. But it's not the over-criminalization. You've got, as the judge has implied, the war on drugs, where you get these long sentences. People get, for a little bit of marijuana, people are getting more time than, or other kind of drugs. You're getting more time than violent criminals. And just the number of people coming in has been vastly affected by the so-called war on drugs. But the conservatives have begun to recognize that all this silliness is not just silly, it's expensive. And when you start talking about spending in a community of 100,000, spending $100 million in counterproductive incarceration, I mean, you're in an order of magnitude, you're getting to the school board budget. Counterproductive. I think that's when the conservatives start noticing something's not right.
It's an executive branch issue too, because the U.S. attorneys or the attorney general could say, we're not going to prosecute all these drug crimes in federal court and let them go to state court. I mean, I get tons of drug crimes that probably should be in state court, but for whatever reason, the incentive of the local prosecutor or the policy of the executive branch, they're in federal court.
They don't have to pay for the incarceration.
Yeah, well, that's good for the defendant, because I think they'd much rather be in a federal prison than in a state.
Yeah, but the sentences are a lot longer usually.
Longer, but.
So, I'd just like to thank our panelists. Give them another big hand.